time, and I'll probably come back later on.
Thank you. Senator Hatch.
Thank you, Chairman Biden. Judge, there are a lot of things that just don't make sense to me in Anita Hill's testimony. I liked her personally. I thought she presented herself well. There's no question she's a very intelligent law professor. She has graduated from one of the finest schools in the land, law schools that is, and her undergraduate work was exemplary. She clearly is a very intelligent woman. And I think everybody who listened to her wants to like her, and many do. But Judge, it bothers me because it just doesn't square with what I think is some of it doesn't square with what I think is common experience and just basic sense, common sense. I hesitate to do this again, but I think it's critical. And I know it outrages you, as it would me, as it would anybody who is accused of these type of activities. Let's see. In her first statement on this issue, really given to the FBI and all over the press, all over the media, about 2 or 3 weeks after Thomas originally asked Hill for a date, he started talking about sex. He told her about his experiences and preferences and would ask her what she liked or if she had ever done the same thing. Hill said that he discussed oral sex between men and women. Thomas also discussed viewing films of people having sex with each other and with animals. He told her that he enjoyed watching the films and told her that she should see them. He never asked her to watch the films with him. Thomas liked to discuss specific sex acts and frequency of sex. That's allegation number 1, given in what I consider to be a pretty decent FBI investigation, pretty thorough, by a man and a woman, FBI agent. In the 4-page statement that she issued, which was of course leaked to the press by somebody on this committee, in violation of law, in violation of the Senate ethics, in violation of a stringent rule formulated because these FBI reports contain raw data. The information from the FBI report was released, and this statement was given. In fact, the reporter who broke the story read the statement to her according to her own remarks. She then said, in this statement, this is the second one, after brief discussion about work, he would turn the conversation to discussions about his sexual interests. His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such things as women having sex with animals and films involving group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or breasts involved in various sex acts. That's the second statement, which is considerably different from the first and adds some language in. And you've denied each and every one of these allegations last night. So I won't go through that again today, although if you want to say anything about it further, I'd be happy to have you do it. Then yesterday, she appeared before this committee, and in her statement yesterday, her written statement, of which I have a copy that was distributed to the press and everybody else, she said his conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. On several occasions, Thomas told me graphically of his own sexual prowess. 3 different versions, each expansive, each successively expansive. Now, Judge Hill, I mean, Judge Thomas, anybody who made all of those cumulative statements, if you take one of them out of context, they're so graphic and so crude and so outrageous, and I think so stupid, that would be enough, in my opinion, to find sex harassment against anybody, if it happened. But if you had all of those cumulatively together, the person who would do something like that over a period of time, really a short period of time according to her, and twice, not twice, but in two different separate agencies, we'll put it that way, that person, it seems to me, would not be a normal person. That person, it seems to me, would be a psychopathic sex fiend or a pervert. Now, Judge, you've had to have thought about this. I know you're outraged by it, and you've denied all these things, and you've said these things did not happen. They are simply untrue. Now, you've had an evening to think about it. Do you have anything further to say about it?
Senator, my reaction to this has been, over the last 2 weeks, has been one of horror. I can't tell you what I've lived through. I can't tell you what my wife has lived through, or my family. I can't tell you what my son's lived through. I don't know what to tell him about this. If I were going to date someone outside of the workplace, I would certainly not approach anyone I was attempting to date as a person with this kind of grotesque language.
I have to interrupt you here, Judge, but there was an implication that you not only repetitively asked her for dates, I don't know, I guess that could be construed as sexual harassment, repetitively asking a woman for dates, but the implication was, and the clear implication which she spoke about, was that you wanted more than dates, if her allegations were true.
Senator, I did not ask her out, and I did not use that language. One of the things that has tormented me over the last 2.5 weeks has been, how do I defend myself against this kind of language and these kind of charges? How do I defend myself? That's what I asked the FBI agent, I believe, for the first time. It's what I've asked myself. How do I defend myself? If I use that kind of grotesque language with one person, it would seem to me that there would be traces of it throughout the employees who worked closely with me. There would be other individuals who heard it, or bits and pieces of it, or various levels of it.
Don't worry, Judge. Probably before the weekend's out, they'll find somebody who will say that.
Well, the difficulty also was that, from my standpoint, is that in this country, when it comes to sexual conduct, we still have underlying racial attitudes about black men and their views of sex. And once you pin that on me, I can't get it off. That is why I am so adamant in this committee about what has been done to me. I made it a point at EEOC and at education not to play into those stereotypes at all. I made it a point to have the people at those agencies, the black men, the black women, to conduct themselves in a way that was not consistent with those stereotypes. And I did the same thing myself.
When you talk in terms of stereotypes, I mean, what are you saying here? I mean, I want to understand this. First of all, let me get back to your first thought. You said that if you wanted to date somebody, or even if you wanted to seduce somebody, you didn't say that, but if somebody, just put yourself in the mind of this, if you had wanted to seduce her, is this kind of language you would use?
This would not be...
Is this kind of language a reasonable person would use? Is this kind of language anybody would use who wanted a relationship?
Outside of the workforce or outside of the workplace, That is not certainly the way that I would approach someone I would want to date. Whether I would date that person for a long time or just go to dinner, that is not my approach. I think that, and I have to reiterate this, that for someone in the workforce to use that kind of grotesque language, it has to show up with other staff members. When we looked at sex harassment cases, when we looked at cases of people involved in unacceptable conduct of this nature, there was always a pattern. The other point that I'm making that is of great concern to me is that this is playing into a stereotype.
Before we get to that, Judge, because I am going to get to that, that's an interesting concept that you've just raised, and I promise I'll get back to it. You're a very intelligent man. There's no question about it. Anybody who watches you knows that. You couldn't have risen to these high positions in government, been confirmed 4 times by the august United States Senate, 3 times by the Labor Committee, upon which a number of us here on this committee serve, and whose staff members were used in this investigation, and I might add, once now before the Judiciary Committee, august committees. She is an extremely intelligent woman. And from all appearances, a lovely human being. Do you think an intelligent African-American male like you, or any other intelligent male, regardless of race, would use this kind of language to try to start a relationship with an intelligent, attractive woman?
Senator, I don't know anyone who would try to establish a relationship with that kind of language.
Unless they were sick.
I don't know of anyone.
I don't even know people who might have emotional disturbances who would try that. Now, I want to ask you about this intriguing thing you just said. You said some of this language is stereotype language?
Senator,
what does that mean? I don't understand.
Language throughout the history of this country, and certainly throughout my life, language about the sexual prowess of black men, language about the sex organs of black men and the sizes, etc. That kind of language has been used about black men as long as I've been on the face of this earth. And these are charges that play into racist, bigoted stereotypes, and these are the kind of charges that are impossible to wash off. And these are the kind of stereotypes that I have in my tenure in government and conduct of my affairs attempted to move away from and to convince people that we should conduct ourselves in a way that defies these stereotypes. But when you play into a stereotype, it's as though you're skiing downhill. There's no way to stop it. And this plays into the most bigoted, racist stereotypes that any black man will face.
Well, I didn't understand the television program, but there were 2 black men. I may have it wrong, but as I recall, there were 2 black men talking about this matter, and one of them said, "She's trying to demonize us." I didn't understand it at the time. Do you understand that?
Well, I understand it, and any black man in this country. Senator, in the 1970s, I became very interested in the issue of lynching. And if you want to track through this country in the 19th and 20th century, the lynchings of black men, you will see that there is invariably, or in many instances, a relationship with sex, an accusation that that person cannot shake off. That is the point that I'm trying to make, and that is the point that I was making last night, that this is high-tech lynching. I cannot shake off these accusations because they play to the worst stereotypes we have about black men in this country.
Well, this bothers me. Bothers me.
Bothers me.
I can see why. let me, I hate to do this, but let me ask you some tough questions. You've talked about stereotypes used against black males in this society. In this first statement, he told her about his experiences and preferences, would ask her what she liked or if she had ever done the same thing. Is that a black stereotype?
No.
Okay. Hill said that he discussed oral sex between men and women. Is that a black stereotype?
No.
Okay. Thomas also discussed viewing films of people having sex with each other and with animals. What about that?
That's not a stereotype about blacks.
Okay. He told her that he enjoyed watching the films and told her that she should see them. Is watching X-rated films or pornographic films, is that a stereotype?
No.
He never asked her to watch the films with him. Thomas liked to discuss specific sex acts and frequency of sex.
No, I don't think so. I think that the last frequency could have to do with black men supposedly being very promiscuous or something like that.
So it could be partially stereotypical then.
Yeah.
In the next statement, she said his conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such things as women having sex with animals, and films involving group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or breasts involved in various sex acts. What about those things?
I think certainly the size of sexual organs would be something.
Well, I'm concerned. Thomas told me graphically of his own sexual prowess, the third statement.
That's clearly
Clearly a black
stereotypical.
stereotype.
Clearly.
Do you think well, what do you feel about that?
Well, Senator, as I've said before, this whole affair has been anguish for me. I feel as though I've been abused in this process, as I said last night, and I continue to feel that way. I feel as though something has been lodged against me and painted on me and will leave an indelible mark on me. This is something that not only supports but plays into the worst stereotypes about black men in this society. And I have no way of changing it and no way of refuting these charges.
Okay. Now let me just, people hearing yesterday's testimony are probably wondering how could this quiet, retired woman know about something like Long Dong Silver. Did you tell her that?
No, I don't know how she knows.
Is that a black stereotype? Something like Long Dong Silver?
To the extent, Senator, that it is a reference to one's sexual organs and the size of one's sexual organs, I think it is.
There's an interesting case that I found called Carter versus Sedgwick County, Kansas, 1988 case, dated September 30th. It's a 10th Circuit Court of Appeals case. It's a district court case. It's a district court case within the 10th Circuit. Do you know which circuit Oklahoma is in?
My guess would be the 10th Circuit. I remember serving on a moot court panel with a judge from the 10th Circuit, and I believe she was from Tulsa.
Well, I have to tell you something. I believe Oklahoma is in the 10th Circuit. Utah is also. It's an interesting case. I'm just going to read one paragraph if anybody wants to read it. And I apologize in advance for some of the language, I really do. It's a civil rights case. Interesting civil rights case. And again, I apologize in advance for the language. I just want to read one paragraph. Plaintiff testified that during the course of her employment, she was subjected to numerous racial... By the way, this is it's an extremely interesting case because the headnote says, black female brought suit against county and county officials contending she suffered sexual harassment and was unlawfully terminated from her employment with county on the basis of her race and sex. Now, anybody wants it, we'll make copies for you. Or you can get it. I'll give the citation, as a matter of fact. It's, the citation is 705 F. Sup. 1474, District Court, Kansas, 1988. Let me just read the one paragraph. Plaintiff testified that during the course of her employment, she was subjected to numerous racial slurs and epithets at the hands of Defendant Brand and was sexually harassed by Defendant Cameron, specifically as to plaintiff's claim of race discrimination. Plaintiff testified that Defendant Brand referred to plaintiff on several occasions as John's, Jon''S, in brackets Cameron, close brackets, token, I apologize for this word, but it's in here, nigger. That is certainly racist. And at other times would tell plaintiff it was nigger pick day, in quotes. Plaintiff claims Defendant Brand kept a picture of a black family in his office, and when plaintiff questioned Brand about the picture, he boasted of his own, and then the word is used again, blood, and of his sexual conquests of black, and I'm not going to say that word. It's a pejorative term. It's a disgusting term. So this man was claiming sexual conquests. Plaintiff further testified that on one occasion, Defendant Brand presented her with a picture of Long Dong Silver. A photo of a black male with an elongated penis. I apologize again. Well, it goes on. It gets worse. Maybe not worse, but it goes on. This is a public opinion that's available in any law library. And I have to tell you, I'm sure it's available there at the law school in Oklahoma. And it's a sexual harassment case. I'm really concerned about this matter. Because first of all, I really don't believe for one instance, knowing you for 11 years, sitting in on 4 confirmation processes, having them pick at you and fight at you and find fault all the way through. And it's fair game with regard to what you did and what you're trying to do, what your excesses were with regard to your job and what your failures were, what your successes were. All that's fair game, and it happened. And you went through it, and you held your dignity and answered all the questions. You confirmed 3 times in a row. And this is your 4th time. And you should be confirmed here. Never once were you attacked like this by anybody. And I know you. And the people who know you the best, and that involves hundreds of people, think the world of you. They know you're a good man. They know this woman's a good woman. And this is not consistent with reality. And I'm not going to find fault beyond that with Professor Hill. I liked her too. She presented herself well. tell you, the Juan Williams piece in the Washington Post telling how all these interest groups have scratched through everything on earth to try and get something on you, all over the country, all over this town, all over your agency, all over everybody. And there's a lot of slick lawyers in those groups. Slick lawyers. The worst kind. There's some great ones, too. And it may have been a great one that found the reference to Long Dong Silver, which I find totally offensive. And I find it highly ironic that you've testified here today that used against you by one who taught civil rights, who came from one of the 5 best law schools in the country, who is an intelligent, apparently decent African American, used against you a bunch of black stereotype accusations. What do you think about that?
Senator, as I've indicated before, and I will continue to say this and believe this, I have been harmed. I've been harmed. My family's been harmed. I've been harmed worse than I've ever been harmed in my life. I wasn't harmed by the Klan. I wasn't harmed by the Knights of Camellia. I wasn't harmed by the Aryan race. I wasn't harmed by a racist group. I was harmed by this process, which accommodated these attacks on me. If someone wanted to block me from the Supreme Court of the United States because of my views on the Constitution, that's fine. If someone wanted to block me because they felt I wasn't qualified, that's fine. If someone wanted to block me because they don't like the composition of the court, that's fine. But to destroy me, Senator, I would have preferred an assassin's bullet to this kind of living hell that they have put me and my family through.
Let me just give you one more. Everybody knows that the worst nightmare for any trial lawyer is to have a person who has an impeccable background, a good appearance, and appears to believe everything that person is saying, testify. And it happens in lots of trials, lots of them. And I've been there, believe it or not. I've lost a lot of the skills, but I've been there. 16 years here causes you to lose a lot of things. You almost lose your mind sometimes. And some have suggested that I have from time to time. But I'm just going to give you one more, because it really offends me, at least. Maybe it doesn't anybody else. Maybe I'm wrong. But I don't think so. I've been through this a lot of times. I've been through this only usually, Senator Biden, I really am going to have to take more time than a half hour if you'll let me. I've got to finish this. I'd really appreciate it, and I've got to finish my line of questions.
Without objection, take the time you want, and then we'll just allocate the time to the next question.
Thank you. I really appreciate that. She testified, one of the oddest episodes I remember was an occasion in which Thomas was drinking a Coke in his office. He got up from the table at which we were working, went over to his desk to get the Coke, looked at the can and asked, quote, "Who has put pubic hair on my Coke?" Question mark, unquote. That's what she said. Did you ever say that?
No.
Did you ever
Absolutely
think,
not.
Think of saying something like
No.
that? That's a gross thing to say, isn't it? Whether it's said by you or by somebody else, it's a gross thing to say, isn't it?
As far as I'm concerned, it is, Senator, and it's something I did not nor would I say.
Ever read this book?
No.
The Exorcist?
No, Senator.
Ever see the movie?
I've seen only the scene with the bed flapping.
Well, I'm going to call your attention. Now keep in mind, Juan Williams said, this great journalist for the Washington Post, I differ with him, but he's a great journalist. I don't differ with him on everything. We agree on a lot of things. And we certainly agree in this area. But he went down what they've tried to do to smear you. He went down that they have the whole country blanketed trying to dig up dirt, just like you've said it. Just like you've said it. And let me tell you, these aren't itty-bitty tort attorney investigators. These are the smartest attorneys from the best law schools in the land, all paid for at the public interest expense. It's what's ruining our country, in large measure, because some of these groups, not all of them, many public interest groups are great. I don't mean to malign them all, but a number of them are vicious. We saw it in the Bork matter, and we're seeing it here. Let me just read to you from The Exorcist. You said you never did say this, who has put pubic hair on my coke? You never did talk to her about Long Dong Silver. I submit those things were found. On page 70 of this particular version of The Exorcist, "Oh, Burke," sighed Sharon. In a guarded tone, she described an encounter between the senator and the director. Dennings had remarked to him in passing, said Sharon, that there appeared to be, quote, an alien pubic hair floating around in my gin, unquote. You think that was spoken by happenstance? And she would have us believe that you were saying these things because you wanted to date her? What do you think about that, Judge?
Senator, I think this whole affair is sick.
I think it's sick, too.
I don't think I should be here today. I don't think that this inquisition should be going on. I don't think that the FBI file should have been leaked. I don't think that my name should have been destroyed. And I don't think that my family and I should have been put through this ordeal. And I don't think that our country should be brought low by this kind of garbage.
These two FBI agents told her to be as specific as she could possibly be, and yet she never said anything about Long Dong Silver or pubic hair. To them, she didn't say it in her statement, her 4-page statement, which is extensive, single-spaced 4 pages. But she said it yesterday. I don't know whether you noticed, but I noticed that whole entourage, not her family, they look beautiful. They look like wonderful people to me. Looked at her parents, they're clearly good people, clearly. Her sisters, clearly good people. But I saw the entourage come in. I'm not saying they did this, but you can bet your bottom dollar that every possible stereotype, to use your terms, I never fully understood that, but every possible stereotype could be dug up. Now, Judge Thomas, I just have to finish just another short line of questions. I'll have others later.
Senator, you're welcome to do that. Can you give us an idea how long you're going to go, or whether we should
if you could give me another 10 minutes, I think
sure.
I would appreciate it.
We have an idea.
First of all, I'd like to put Juan Williams' article into the record at this point.
Without objection.
Okay. The phone calls came throughout September, Juan Williams said. Did Clarence Thomas ever take money from the South African government? Was he under orders from the Reagan White House when he criticized civil rights leaders? Did he beat his first wife? Did I know anything about expense account charges he filed for out-of-town speeches? Did he say that women don't want equal pay for equal work? And finally, one exasperated boy said, "Have you got anything on your tapes we can use to stop Thomas?" The calls came from staff members working for the Democrats on the Senate Judiciary Committee. I didn't say that. I'm just repeating it. But I know it's true. They were calling me because several articles written about Thomas have carried my byline. When I was working as a White House correspondent in the early 80s, I'd gotten to know Thomas as a news source and later wrote a long profile of him. The desperate search for ammunition to shoot down Thomas has turned the 102 days, this is just a few days ago, 102 days since President Bush nominated him for a seat on the Supreme Court into a liberal's nightmare. Here is indiscriminate, mean-spirited mudslinging, supported by the so-called champions of fairness, liberal politicians, unions, civil rights groups, and women's organizations, all of whom Juan Williams has regard for, or at least did up till this article. I'm just reading excerpts. Now the Senate has extended its attacks on fairness, decency, and in its own good name by averting its eyes while someone in a position to leak has corrupted the entire hearing process. It couldn't have been said better in one paragraph. Somebody on this committee, by releasing a sealed affidavit containing an allegation that had been investigated by the FBI, reviewed by Thomas's opponents and supporters on the Senate committee, and put aside as inconclusive and insufficient to warrant further investigation to stop the committee's final vote. It's an interesting article. I commend it to everybody. Judge Thomas, I have a copy of a November 14, 1984 memorandum concerning sexual harassment that you issued within the EEOC. The memo emphasizes the importance of an earlier EEOC order issued shortly before your arrival at that agency. Now, Judge Thomas, before I get into that memo, I would just like to say this to you. And I wrote it down because I wanted to say it right. I have to tell you, Judge Thomas, I have reflected on these hearings with my handwriting. And what's unfolded this past week is terrible. One of the things that I find most ironic is that many have tried to turn this issue into a referendum on sexual harassment. Well, let me say, this is not a referendum on sexual harassment. We all deplore sexual harassment. We all deplore the type of conduct articulated here by Professor Hill. But the most ironic thing to me is, it's easy for us on this committee to say that we deplore sexual harassment. And many on this committee have said it in the past and during these proceedings and before the media. But you, Judge Thomas, you've spent your career doing something about it. A heck of a lot more than deploring sexual harassment. You and your people at the EEOC have been directly involved and have done a lot about it, and I know that. Because along with Senator Kennedy and the other members of the Labor Committee, we oversee what you do. Now, the memo that you issued to the EEOC on sexual harassment, this emphasizes the importance of an earlier EEOC order issued shortly before your arrival at the agency. And that memo stated in unequivocal terms that sexual harassment is illegal. The final paragraph of the memo, which was signed by you, reads as follows: I expect every commission employee to personally ensure that their own conduct does not sexually harass other employees, applicants, or any other individual in the workplace. Managers are to take the strongest disciplinary measure against those employees found guilty of sexual harassment. Sexual harassment will not be tolerated at the agency, underlined. Now, Judge Thomas, did this memo reflect a major policy commitment of yours?
It expresses my strong attitude and my adamant attitude that sex harassment was not to take place at EEOC.
Judge Thomas, I also have a copy of an EEOC plan for the prevention of sexual harassment issued in 1987 while you were chairman of the Equal Employment Opportunity Commission, which clearly states that sexual harassment includes, quote, unwelcome sexual teasing, jokes, remarks, or questions, unquote. Now, is this consistent with the views that you personally have believed in and abided by during your lifetime?
Yes.
Or certainly in these last 10 or 11 years?
Yes, Senator.
Which are the years in question. Was sexual harassment tolerated within the EEOC by you as chairman or while you were chairman?
Absolutely not.
Did you make clear your views to those who were around you and who were working with you on sexual harassment?
Yes, on many occasions.
I would like just to bring up briefly to ask you what your experience was in handling sexual harassment charges within the EEOC itself while you were the chairman of the EEOC. I realize that most of the relevant information is contained in confidential employee files, but a few general questions would be in order at this point, and you've been asked about this already, but this, I think, needs to be clarified. There were a number of such charges brought and processed within the EEOC while you were there, were there not?
That's right, Senator.
And these...
Excuse me, just to interrupt, not for your time. I made a ruling yesterday, and you're fully within your rights, and if the judge would like to go on it, that we can continue, that the conduct at EEOC on sexual harassment was not at issue. Now, you put it back an issue, which I understand. It's going to be hard.
It's not an issue, but it was made an issue.
No, well, I ruled it out of order yesterday. It was not allowed to be an issue. Okay. Now, it seems to me that Senator Heflin has a right to go back and question now on that issue.
On this particular issue, I have no problem.
Fine, okay. Because I cut Senator Heflin off, and I still think it's beyond, I don't think he should have to answer questions about his conduct at EEOC in terms of what his policies were. But if that's the case, then it's going to be hard for me to fairly sit here and rule that one person can ask those things that relate to one type of administration of that issue, and another senator cannot ask countervailing questions. But I just want to make that point.
Well, I appreciate it, but the real purpose of this is not to go into the matter any deeper than Senator Heflin did, but just to rebut what was said in his questioning. And that's the only reason I'm doing this. And I don't want to go any further. I don't want to particularly open up the whole issue, although, I'm sure he'd be happy to discuss it. But I think, frankly, let me just do this. I think you'll see why it's relevant under the circumstances.
No, I
didn't object
think it
to
is
after.
relevant. I just want you to make
No,
sure
but I
you
mean,
understand.
as a rebuttal to what was said.
Well, there was no rebuttal. I cut the senator from
After
go ahead.
a number of comments were made, I want to clarify.
Fine.
Maybe I should have objected earlier, but I didn't, and I think this needs to be clarified. Now, again, I repeat, I believe most of the relevant information is contained in confidential files there at the EEOC, which I think the EEOC maintains as confidential, unlike the Senate Judiciary Committee. There were a number of other of such charges brought and processed, you've just said, within the EEOC. You handle these matters, right?
That's right.
And these cases would have been investigated by the General Counsel's Office with dispositions recommended by that office and then approved by yourself as chairman of the commission itself. Is that correct? Is that a fair statement?
It would be approved by the whole commission.
Now, just to the specific point, I want to give you a chance to speak on it. Now, reference was made earlier today to the Harper case, or last night to the Harper case. In November of 1983, the very time relevant to today's charges, you sent a memorandum to the General Counsel of the EEOC, David Slate, in which you concurred in a recommendation to terminate Mr. Harper's employment because of sexual harassment charges, and that you specifically noted your view, your individual view, that termination is severe, a punishment as it is, was in that case, quote, too lenient, unquote, punishment.
I generally remember either handwriting that on the memo. I felt very strongly that he should have been fired. And that was either handwriting that on the memo. I felt very strongly that he should have been fired. And that was my view at the time. I felt and continue to feel that individuals engaged in this conduct should be fired. And that's the approach I took at EEOC.
Well, there are a lot of other things that I could go into to show that you've been a champion in this area for women. You've been a champion in many ways for a lot of us. I've taken way over the allotted time, but I felt it was essential because I really am starting to become more than I have been outraged about the way you've been treated. I've been outraged over the way this committee has treated you, and I think Senator Biden and Senator Thurmond did everything they should have done. They handled it like every prior difficult decision. And the chairman, I have great respect for him for that. But somebody on this committee has abused the process, and I'm not going to be happy with just an ethics investigation. I don't think anybody is.
I'm going to order one, though.
I want you to order an FBI investigation. I want an investigation by real, appropriate, non-Senate staffers. I want some people who aren't affiliated with the Senate to look into this matter, because I think that's the only way we even have the slightest chance anyway of getting to the bottom of it, and then we probably won't. But if we're fair, this is not, as I said at the beginning, the nomination of a justice of the peace to some small county in some small state. This involves the very integrity and fabric of our country. And I also want to say that the burden of proof is certainly not on Judge Thomas. This is America. This is America. The burden of proof is on those who use statements that are stereotypical statements. I thought when we were talking about stereotypes law that we were talking about the exorcist and some of these things that apparently some very bright minds out there have found to help make this dramatic in a destructive way to these good people. Mr. Chairman, I'll come back again and try and finish the rest of my question.
Thank you. Let me make one thing clear. One is there will be an investigation of this matter, because I believe not only has the judge been wronged, Anita Hill has been wronged, and the process has been wronged. And one other point I'd like to make, I think it's appropriate to take a break in a moment, but I'd like to ask my colleagues, and I want to make it clear to the press, I'm about to ask my colleagues to caucus with me, and there's nothing that is of any consequence in the caucus other than trying to figure out the schedule for the rest of the day. And what we will do is, if my colleagues be willing to caucus across the hall with me now for a few minutes, and we'll recess for 15 minutes, Judge, and then come back.